Hello everybody, I'm attorney Nathan Hauser of Hauser Law, and in this video I want to talk about evaluations with qualified medical evaluators, QMEs, or agreed medical evaluators, AMEs. What they are and what you need to know. When you are evaluated by a qualified medical evaluator or an agreed medical evaluator in a California workers' compensation case, it is an important appointment. First, let's talk about a QME, a qualified medical evaluator. If you are evaluated by a QME, that doctor is usually issuing a second opinion in your case. A QME list is issued by the state, and usually that doctor is requested by the insurance company to confirm or deny what another doctor in your workers' compensation case has said about if you have sustained an injury in your case, if you need time for temporary disability to be out of work, if you have suffered permanent disability as a result of your injury, if you need future medical care, and lastly, whether you have restrictions that would allow you to return to that line of work, which you previously had, or whether you should not return to that line of work. Therefore, we want the doctor's opinion to be as favorable to your case as possible. Two medical opinions saying the same thing are stronger than just one. Generally, if the second opinion QME doctor agrees with your primary treating doctor, those opinions are going to control what happens in your workers' compensation case and ultimately what your case is worth. Occasionally, it may be my office that requests a QME evaluation or a state doctor. This usually happens when you've been seen by a workers' compensation clinic doctor that your employer sent you to, and that doctor gave you a bad report. In that circumstance, we want the QME doctor to issue a report that more appropriately describes your injury, disability, the need for future medical care, and possibly a job voucher. In other words, we want that report to be the stronger evidence in your case in the event that we need to take your case in front of a judge. We want the QME's opinion to maximize the benefits that you are allowed in your workers' compensation case. Now let's talk next about what an AME is, an agreed medical evaluator. That is also a doctor that is going to evaluate you, not treat you in your workers' compensation case. That doctor will be agreed upon by my office and the attorneys for the insurance. In my practice, I am very particular and selective about the doctors that I will agree to serve as the agreed medical evaluator in your case. There is a big reason for this. When you are evaluated by an agreed medical evaluator, that doctor will generally control the outcome of your case. His opinion generally will prevail over the opinions of any other doctors that have issued reports in your case. For that reason, I will only agree to doctors that I truly believe will be fair to my client. We want the agreed medical evaluator's opinion to maximize the benefits that you are allowed in your workers' compensation case. Usually, the value in your case will come from the permanent disability resulting from the injury and the future medical care necessary to treat your injuries. We want the QME and also an AME to give you the maximum permanent disability for your injuries and the maximum provisions for the future medical care necessary to treat your injuries as well. Both a QME and an AME will give their opinions about appropriate periods of temporary disability in your case and whether or not your work injuries require that you have restrictions when you return to work. If you still work for your employer and you want to return to your job, it is important that you let the doctor know those facts because he will be in control of the level of the restrictions that you have when you return to work, and he has the choice of determining how light or how heavy those restrictions are. Now, next I want to give you some rules to follow for your examination. And I think that everything should go well if you follow these rules. Number one, always tell the truth. I cannot emphasize this enough. Always tell the truth. And just to make sure you understood me, I'm going to say it another way. Do not lie to these doctors. Before an AME or a QME evaluation, and also with my clients before depositions, I always tell them something that my father told me when I was a child. When you tell the truth, you don't need to remember anything. And usually my clients that follow this instruction, they have the best outcome. So always tell the truth with these doctors. Next rule, show up early to your appointment. Arrive early and do not be late. Doctors are very busy people. No doctor wants to be waiting around for you to show up late at your appointment. We want the doctor to be as favorable to you as possible, and we don't want any reason for the doctor not to like you. So show up to your appointment, be early, do not be late. When you are talking with the doctor, be nice to the doctor and do not argue with him. Again, We want this doctor's report to be written in your favor. Do not argue with the doctor because he is going to make decisions that can seriously affect the outcome of your case and your case's value. The next rule, make sure that you tell the doctor all of the complaints that you have, physical complaints and other complaints. If you are being evaluated by an orthopedic surgeon, it's important that you let the doctor know about all of the body parts where you have pain, even if those pains are not present all the time. Another thing I want you to think about is how you would describe the pain that you have in different parts of the body when you are asked by the doctor. Sometimes describing pain when you are asked that question, it's kind of difficult. For example, some pain is dull, achy. Some pain can be sharp, pulsating, or feels like pins and needles, or tingling. Sometimes a part of the body may click or pop with certain movement. Think about how you would describe the pain that you are having to the doctor. A description of pain is often something that the doctors will use when determining a diagnosis as well. If you, in your particular case, have low back pain, and you feel like there's pain, numbness, or tingling that travels to your legs, feet, or toes, be specific with the doctor about where on your legs, feet, or toes you feel those sensations. For example, do not tell the doctor that you feel pain in your entire foot if you only feel sensations in your small toe. If you have, in your case, injured your neck, or you have neck pain, and you feel like the neck pain travels to your arms, hands, or fingers, be specific with the doctor about where on your arms, hands, or fingers you are feeling those sensations. Again, for example, do not tell the doctor that the pain travels to your entire hand if you only have pain in your small finger and your ring finger. If you feel like you have muscle spasms in any part of your back, or you feel like when you bend forward, backward, or to either side, if you have pain in doing so, these are all important things that the doctor needs to know. When you are explaining the injuries and the pain that you have to the doctor, I want you to take your time. Don't feel rushed. If you are filling out pain diagrams at the time of this appointment, I want you to make sure that you indicate all of the body parts where you have complaints on that pain diagram. The next rule, I want you to tell the doctor if you have any medical conditions that have been affected by your work injury or by the pain from your work injury. For example, if you have hypertension, high blood pressure, or diabetes, and your blood pressure levels or diabetic levels have gotten worse from your work injury, we want the doctor to know about that, even if he's not a specialist in any of those conditions. If you feel you have been diagnosed with hypertension or diabetes for the first time after your work injury, we also want the doctor to know that. Also, if you have other complaints besides physical pain, like stress, anxiety, stomach complaints like constipation, heartburn from the medications that you take for your work injury, you must let the doctor know about those complaints. If you are filling out a questionnaire that asks whether you have other issues like hypertension, diabetes, chest pain, stomach pain, stress, and you do, it's important that you indicate that on those questionnaires. The next rule, tell the doctor if you reported your injury to your employer or if you made comments to anybody about your pain at the job. A lot of the time, the insurance companies will deny a case because they will say that the injured worker never reported the injury or pain that they have had on the job. If you reported your injury or physical complaints in writing or verbally to a supervisor at work, let the doctor know that you told them about the injury or the pain. You should also do the same if you're asked those questions in your deposition. The next rule, tell the AME or QME doctor about how the injury or injuries occurred. In workers' compensation, there are two types of injuries. One is called a specific injury. That means that something occurred on one specific day. For example, you slipped and landed on your back. And the other type of injury under California law is a cumulative trauma. This usually means that the injury or pain did not occur at one specific moment, but that the injury occurred over a period of time, which could mean months, weeks, years. If your injury happened on one day, a specific injury, you will be asked what body parts you had pain in immediately after the injury. You may also be asked if you developed pain in any other parts of the body after the injury. If your injuries or pain occurred over a period of time and not necessarily on a specific day, the doctor may ask approximately when you started having complaints in each of those affected body parts. If you can do so, I want you to give the doctor an estimate if you don't know exactly. When you are asked about your medical history, this is a very, very important rule. Tell the doctor about all accidents and injuries that you can remember that happened before your work injury and after your work injury, if any. The doctor will ask if you have ever had any past injuries at work or outside of work at all in your entire life. This includes injuries at other jobs. You will be asked if you've ever been involved in any motor vehicle accidents. This even includes car accidents when you were not hurt or even just the bumper of your car was scratched. Even if you had a scratch on your bumper and your car insurance company fixed the scratch, that qualifies as a motor vehicle accident. If you do not tell the doctor about that accident, even if you were not hurt, and he later learns about the accident from the defense attorney or the insurance company, that can ruin your credibility in the eyes of that doctor. Always tell the truth, and to the best of your recollection, report any past injuries that you've had. The next rule kind of goes in line with the previous rule. Don't hide any information from the doctor about your medical history. Do not think that hiding information from this doctor will help you. With agreed medical evaluators or qualified medical evaluators, or all medical evaluations in your case for that matter, we want to give the doctor all of the information up front so we are not surprised later and that you are not later accused of being dishonest. It will always work out for the better if you tell the truth. I can always work with the truth, and I promise you that the truth will always bring the correct outcome. The next rule. Be honest with the doctor about your pain levels and tell him if your pain is different when you take medication. The doctor may ask you on a scale of 1 to 10 what your level of pain is at the time of the evaluation. I must warn you, the pain scale that doctors use is generally as follows. A 1 means you have little or no pain at all, and a 10 means that you are in excruciating pain and that you need to go to the emergency room. From my experience, when my clients say that their pain levels are at a 9 or a 10, or that they're at a constant 9 or a constant 10, the doctors generally think that my clients are exaggerating their level of pain. Do not exaggerate your level of pain, but also do not minimize it. The next rule, if you work a second job, I cannot explain how important this is. Tell the doctor about your second job, even if you are just a caretaker for a family member and getting paid by the state. Once again, if you continue to do any job at all after your injury or at the time of your evaluation, even if it's part-time or a light-duty job, you absolutely must tell the doctor about that. Doctors do not like when patients lie to them. We need the doctor to have an accurate understanding of what you can do and what you cannot do. If you have 2 jobs and you feel like you cannot do one, but you feel like you can do the other, tell the doctor why. For example, if one job is more physically demanding, like you work as a construction worker, but at night you take care of your elderly parents and the state pays you to feed them their medication and watch over them, then explain that to the doctor. If you get paid by someone to work, that is considered employment and the doctor needs to know about it. Please know this is very important. If you are receiving temporary total disability benefits from the insurance company and you are working at another job, that is a crime. To avoid any trouble, you must let the doctor know if you have any other jobs and find out if he thinks that you can continue working for that other job. The next rule, be honest and be careful when you are asked about your activities of daily living. When a doctor decides the level of permanent disability somebody has suffered from a work injury, he will take into consideration how the injury has affected the person's normal life, activities of daily living, and they are very important considerations. For example, if because of your injury you have difficulty putting on your clothes, putting on your shoes, taking a shower, walking for long distances, standing for long periods of time, sitting for long periods of time, driving, getting in and out of your car, carrying items, then those are things that the doctor needs to know about. But what I'm going to say next is very, very important. Do not tell the doctor that you cannot do something if you can do it. Something insurance companies love to do is send investigators with video cameras to film what it is that you are doing. If you tell the doctor that because of your pain you cannot wash your car, but you really do wash your car, even if sometimes, the insurance company can film you doing that, and if the doctor sees those videos, the doctor is going to question your credibility. If you tell the doctor that you can never stand for more than 20 minutes, but an investigator films you standing for 3 hours at a concert, the insurance can show a doctor those videos and the doctor is going to think you are dishonest. We do not want that. We want the doctor to have a true understanding of your injury and your limitations. But remember, being able to do something with difficulty or pain is completely different than saying that I cannot do something at all. One last point and comment. Our goal is for this AME or QME evaluation that the doctor writes a report in your favor, provides you the maximum level of permanent disability for your injuries, and provides you the maximum future medical care to treat your work injuries. Remember, be completely honest. Usually, once I receive these reports, we will determine what's next. If further work needs to be done, for example, the doctor recommends that you be seen by other specialists, or the doctor recommends coordinating studies, diagnostic studies, we may take those steps. Or your case after this report issues may be in a position to be resolved. Just remember, with these AME and QME evaluations, you need to be honest with the doctor about everything. That is the most important. Once again, I'm attorney Nathan Hauser of Hauser Law. Thank you for watching, and good luck.